So, ladies and gentlemen, good evening. I welcome you all to the national webinar on appointment of distinguished jurists as judges in India. We have eminent speakers here. Justice Sikri has also joined. Justice Sikri, Honorable Justice Sikri, former Judge, Supreme Court of India. Welcome, sir. He is currently the judge at the Singapore International Commercial Court. He will be speaking to us as the chief guest today. We have Professor Dr. Balram Gupta, former head of the Department of Laws, Punjab University, former director, National Judicial Academy, Bhopal, senior advocate and currently director of the Chandigarh Judicial Academy. Professor Yogesh Pratap Singh, the Registrar of National Law University, Odisha. Professor Khagesh Gautam, Associate Professor from Jindal Global University. Dr. Lokendra Malik, whose brainchild this webinar and the entire concept of the subject of discussion today. It is due to him that this has been made possible. It is his article which gave the impetus for us to come up with a topic of discussion such as this. In fact, I would like to share and show you our book on judicial review, which was published in honor of Professor Upinder Bakshi, one of India's most eminent jurists, published by the Cambridge University Press. Justice Sikri has contributed an excellent foreword to this. Professor Gupta has also written a very significant article, as well as Professor Yogesh Pratap Singh. Dr. Malik's article is the basis of our discussion, and it's chapter number 13. 13 you would consider unlucky, but I think it's really lucky for all of us. So the topic is a very interesting one, because despite having a provision in the Constitution, this provision has never really been exercised. And, you know, Indian jurists perhaps have been offered some, I mean, I don't know about others, but Professor Upendra Bakshi, it is said, was offered the judgeship of the Supreme Court at one time. However, we are not certain what happened, and it continued to remain on the books without being utilized. And we do say that most law professors are distinguished, and many would also qualify for the additional term of jurists. But unfortunately, their contribution to the legal profession remains unrecognized in this particular area. Dr. Malik, your contribution has been significant on the topic, and I would therefore request you to deliver the welcome address to our speakers and our audience today. Dr. Malik is a man who combines the twin worlds of advocacy and academics. He has an extensive knowledge of both fields, something like Professor Gupta, which I'm aware of. So there could not have been a better person, in fact, to commence today's discussion, to turn the letter of law into spirit as well, and to emphasize the need for suffusing the Indian judiciary with brilliant legal minds. Dr. Lokendra Malik. Yes.
Professor Dr. Balram Gupta, my colleagues, Professor Y.P. Singh and Professor Gautam, Professor Shruti Bedi, ladies and gentlemen, good evening. Today, we are fortunate to have a very distinguished panel of speakers, including Justice A.K. Sikri, who has been the senior most judge in the Supreme Court of India and remained a member of the Supreme Court Collegium, which finalizes the names of the Supreme Court and High Court judges. As most of you may be aware, that our Constitution has a provision of the appointment of distinguished jurists, but no such appointment has been made from this category during the last 70 years. I'm surprised to note that not even a single judgment of the Supreme Court of India, there have been 3-4 landmark judgments relating to judges' appointment, discuss anything about the appointment of eminent law professors as judges. And I'm equally disappointed to observe that even the legal academia has not taken this concept or has not taken this idea seriously. When I wrote my article, then I came to know that many distinguished professors like Professor P.K. Tripathi and Professor Upendra Bakshi, their names have been considered for judges' appointment from this category. Those proposals were not materialized. I think the time has come when the legal profession, all the stakeholders of the legal profession, including the judiciary, bar, and even the policymakers or government, should take this concept seriously, and a distinguished jurist, particularly a law professor, should be appointed as a judge in our top court. And I think this experiment should not be delayed. And I'm sure that if some eminent law professor is appointed as a judge of the Supreme Court of India, he or she can make a visible contribution. There are many areas where the eminent legal academics can make contribution in constitutional cases, in criminal law cases, particularly in cases which are decided by the constitution benches. So I look forward to hearing the scholastic views of our professor judge, scholar judge, Justice A.K. Sikri, who will share with us the practical inputs, because he has been a part of the Supreme Court Collegium, which takes decisions regarding appointment of judges. And I will also be very, very grateful to all other panelists, Professor Gupta and my colleagues, Professor Y.P. Singh and Professor Gautam, that they could share their views about this unique concept. Thank you very much. I welcome you all to this webinar. Thank you.
Thank you so much, Dr. Lokendra Malik. Indeed, we are looking forward today, this evening, to hear our eminent speakers. I would now like to request Professor Khagesh Gautam, who is Associate Professor of Law at the Jindal Global Law University. He has also worked on this particular issue. His article in the newspaper last year was a significant contribution to this perspective. We look forward to hearing your thoughts today, Professor Gautam.
Dr. Bedi, thank you for having me. Justice Sikri, Professor Gupta, other distinguished scholars, and all the people in attendance. So far as the appointment of judges, a distinguished jurist, I mean, any definition of a jurist must include a law professor, and distinguish how distinguished the law professor is, of course, will depend on the body of work that the law professor has produced. But I have 3 things to say. I'll briefly mention them, but I can elaborate on any 3 of them if I'm asked. So to begin with, the Constitution of India, Article 124, sub-article 3, clause C, says that any person who is in the opinion of the president a distinguished jurist can be appointed to the Supreme Court of India. The constitutional text does not prohibit a law professor to be appointed as a Supreme Court judge, as we very well know that the appointment of judges to the Supreme Court and to the High Courts is now and has been in the hands of the Supreme Court Collegium. The law on that is very well settled and needs there is no need to rehash all that law here. As to why the Supreme Court Collegium has not been able to identify even one distinguished jurist or a law professor of sufficient distinction to be recommended to the president for appointment to the Supreme Court is a question that requires some careful examination. Very interesting question. But the fact is that it hasn't happened so far, and there is no prohibition constitutionally as such. So it's all about how the provisions are being worked. Secondly, and as Dr. Bedi has mentioned, I rather co-authored an article with Dr. Rajkumar, the Vice Chancellor of Jindal Global University. And in that article, both of us took the position that if it is considered appropriate by the people, then law professors are a good constituency from which potential appointees to the bar, to the bench, could be selected. Then there is no reason for the appointment of a distinguished law professor to be restricted just to the Supreme Court. Article 213 of the Constitution should be amended, and a distinguished law professor should also be allowed to be considered for appointment for the High Court. That's the position that we have taken. Of course, it requires a much longer and a much bigger debate as to whether or not the people deem it appropriate. And once they do, there is no reason why the Constitution itself can't be amended. The third thing that I had to say, so first, to the Supreme Court, there is no prohibition of appointment. Supreme Court Collegium hasn't actually recommended anyone as to why only the Collegium can answer. Second, if it is considered appropriate to have law professors as judges, then why should we restrict them to the Supreme Court? We can have them in the high courts as well, but for that, Article 213 of the Constitution will have to be amended. Lastly, and most importantly, there are a whole host of tribunals that we have in our country. There is absolutely no reason why law professors cannot be appointed to these tribunals. And I'll give you one example, and I will not just talk about tribunals, but I would expand my argument to include a whole host of regulatory bodies. But just for example, I would mention here the Central Board of Film Certification. Now, censorship of films is constitutionally permitted under our law. We all know that. Now, it's one thing to say that as a doctrinal or a structural position, any kind of censorship on movies can't be had. That's a constitutional argument, and that is an argument to be made in front of the courts. However, if Central Board of Film Certification is going to impose censorship on films, which is an expression of art, the expression whereof is protected as a fundamental right under our Constitution, then I would like to ask the question, would it not be useful for the nation as a whole and for the arts as a whole to have a trained constitutionally, somebody trained in constitutional law, especially the law of freedom of speech and expression, to be appointed as one of the members to the Central Board of Film Certification, so that the power to censorship movies, when the power is exercised, some sort of balance is struck, and you have an expert ready at hand to offer valuable assistance. You can expand this example and you can add the Income Tax Appellate Tribunal, the CCI, the Appellate Tribunal of the Competitions Commission, and a whole host of other bodies. So to conclude, three things. Number one, to the Supreme Court of India, there is no constitutional prohibition. A distinguished jurist can be appointed. If a law professor sufficiently answers that description, then the person should be appointed by the Collegium. As to why the Collegium has not appointed, only the Collegium can answer. Secondly, if the nation as a whole thinks that law professors can contribute in in judicial decision making, then absolutely we should amend Article 213 itself and allow law professors to be appointed to the High Court bench as well. Thirdly, there are a lot of tribunals and regulatory bodies in India that have to be manned by experts in domain specific expertise, and for that purpose we can have the services of the academics. And I'll just take 30 seconds to conclude my point. There's one last important point. Appointment of professors to the bench allows the institution as a whole to have some theoretical consistency in their decisions that explains every decision. Now, I am personally aware of some decisions in 2019 where one 3-judge bench has overruled another 3-judge bench. Now, if I am a High Court judge and I am confronted with 2 3-judge bench decisions, one has been overruled by another 3-judge bench of the Supreme Court, I will be in a conundrum. And those kind of theoretical inconsistencies, I believe the Honorable Supreme Court of India should avoid. With that, I'll conclude my remarks. Thank you.
Thank you so much, Professor Gautam, for your suggestions and points which you have so succinctly put across to our audience. Professor Dr. Yogesh Pratap Singh, Registrar, National Law University, Odisha, is a distinguished professor whose knowledge and humility make for an attractive combination. I am sure he has much to share with us on this subject as well. I would like to therefore invite Professor Singh to share his thoughts about the topic.
Thank you, Professor Bedi. Good afternoon, all the distinguished members of this panel. Honorable Justice A.K. Sikri, Professor Balram Gupta, Dr. Loken Malik, Professor Bedi, Professor Gautam, and all the participants. I feel humbled, I feel privileged to be part of this panel on this very important issue to discuss one of the most, I would say, highly disregarded clause of the Indian Constitution till now. And unfortunately, this has been very conveniently or silently, this has been ignored by all the stakeholders, including the professors, including the legal academia, because this concerns legal academia, but they have also not pursued this particular aspect of the Indian Constitution. I thank Justice Honorable A.K. Sikri, who agreed to speak on this particular aspect, and not because he has retired now from the Supreme Court, but he spoke on this particular issue when he was in the office also. So thank you very much, sir, for agreeing to speak on this particular aspect of the Indian Constitution, which has not been given due recognition importance. As Dr. Loken Malik and Professor Gautam both mentioned that Constitution has made a provision in Article 124, Clause 3, and there are three categories of people who can be appointed as judge of the Supreme Court. The first category is the High Court judge who has 5 years experience. Mostly they are appointed, elevated to Supreme Court. And then the second category is practicing lawyer who can be directly elevated to Supreme Court. That has also been, that has not been used frequently, but yes, it has been used. And I remember 5 to 6 people, they have been directly elevated, starting from Justice S.M. Sikri, Justice Kuldeep Singh, Justice Hegde, Justice Rohinton Nariman, Justice U.U. Lalit, and Justice Indu Malhotra. They have directly elevated to Supreme Court from bar. But the third category talks about a distinguished jurist in the eyes of the president, who can also be elevated to the Supreme Court directly. But this has not been used till now. In the last 70 years, this has not been used. If you see the background, why this provision was added in the Constitution, in the draft Constitution, this clause was not there. But this was added on the recommendation of 2-3 very prominent members of the Constituent Assembly, people like H.V. Kamath, Mr. M.A. Iyengar. And I will not read the speeches in the Constituent Assembly where he pursued this clause, particular clause to be added in the Constitution, and finally it was agreed and it was added in the Constitution. But the very sense of this speech was they not only argued for this clause because this will bring a new outlook in the justice delivery process in the apex court, but it would also widen the field of choice. As he rightly mentioned, Dr. Khagesh Gautam rightly mentioned that this will widen the scope and the choice when you are going to appoint judges. And this is one of the areas where I think the government have also struggled and collegium is also struggling. Whenever we ask question, we raise question why we don't find more women judges in the High Court and Supreme Court. And the answer given by the government and answer given by the collegium now that we don't have choice. Our choice is very limited. Why we don't find good judges from minority section? Why don't we find good judges from scheduled caste, scheduled tribe section, backward communities. And the reply is that we don't have choice. And this was the precise reason why this clause was added in the constitution, that this will widen the choice when you are going to appoint judges of the Supreme Court. In fact, as he mentioned, Dr. Gautam mentioned that there can be provision for the High Court judges also. A similar clause can be added in the High Court also. One of the members, Mr. Siban Lal Saxena, he specifically recommended a clause to be added, similar clause to be added for the High Court judges also, in Article 217. But this was not accepted. Finally, it was rejected by the Constituent Assembly drafting committee. And later, I think Dr. Malik would verify that in 1976, when 42nd Constitutional Amendment was made, a similar clause was added in Article 217, which made provision for appointment of a distinguished jurist even in the High Court. This amendment was made, but after some time, this amendment was repealed because 44th Amendment was made, and 44th Amendment was made precisely for the reason that we have to undo what was done by the 42nd Constitutional Amendment Act. So everything which was given by 42nd Constitutional Amendment Act was undone by 44th Constitutional Amendment, including that clause in Article 217, without giving any specific reason, without any application of mind, why this clause was added and why this clause is now being deleted on a very after a short time. The only reason we could infer that because 42nd Constitution Amendment was made by Indira Gandhi during emergency, 44th Amendment was made to undo what Indira Gandhi did during emergency. And when people like H.V. Kamath, Iyengar and Siban Lal Saxena, they made these recommendations, this was not based on any hypothetical situation. So there was a strong basis for this recommendation and this argument, and they suggested in their speech that we have Justice Felix Frankfurter in American Supreme Court, who was appointed by President of United States as a judge, and he was professor in Harvard Law School, Harvard University, and he emerged as one of the most illustrious judges of the American Supreme Court. We have examples of International Court of Justice at Hague, where professors are appointed as judges of the International Court of Justice. It is not only Frankfurter. There are many judges who are even later also Justice A.M. Kennedy, Justice R.B. Ginsburg, Justice Stephen G. Breyer, and recently Justice Antonin Scalia, a very famous judge of the American Supreme Court who happened to be a professor of law and finally became a judge, appointed as a judge of the American Supreme Court, and he was proved to be one of the best judges. This improved the decision-making process and the quality of judgments of the American Supreme Court, which I think every judge and every Supreme Court bench of they cite so many cases of the American Supreme Court without any exception, without any. But when we talk about
you made an excellent suggestion, and we should look at other countries, especially America, which is following such a great practice for this.
Yes. Our legal academia has also produced, as Professor Bedi mentioned and Dr. Malik also mentioned, many jurists like Dr. P.K. Tripathi, Professor G.S. Sharma, Professor Upendra Bakshi. I heard that his name was recommended, but nobody knows how it was recommended, why it was rejected, who rejected. There is no information on this aspect also. People say that P.K. Tripathi's name was also recommended, but there is no concrete, authentic information who recommended and why this was not considered and given a final shape. we had people like scholars like MP Singh. Even recent times we have many scholars, eminent jurists. I can't name anybody, but there are many people who deserves to be considered for this particular class, but I don't know why this provision, this clause has not been given enough. At least government, I think that government, when this appointment process was in the hands of government, they at least considered Professor Upendra Bakshi's name or P.K. Tripaঠি's name, but collegium has not even considered. I don't know whether they have considered anywhere name of any distinguished jurist or law professor in for the appointment of judges of the Supreme Court. So briefly, I wanted to bring this aspect of the this clause of the Constitution. I think we'll hear more from Justice Sikri and Professor Balram Gupta because they are experienced people, and we would learn also. Thank you very much.
Thank you so much, Professor Dr. Yogesh Pratap Singh, for such a great example of the comparative aspect from other countries that we should imbibe in our system as well. Professor Dr. Balram Gupta. Well, a daughter may not be able to do justice in introducing her father, but I can say that he is definitely a unique combination of professorial abilities and smooth advocacy. His tribe is indeed rare. And after his innings as the head of the law department at Punjab University, when he became senior advocate and thereafter the director of National Judicial Academy, and now presently at the Chandigarh Judicial Academy, his contribution to the legal field remains unparalleled. Professor Gupta, I would like to invite you now to share your thoughts.
Thank you, Shruti. Justice Sikri, Professor Yogesh Pratap Singh, Dr. Gautam, Dr. Lokendra Malik, Professor Bedi. This is an important aspect. In the year 1953, the Mount Everest was scaled. During the last 70 years, a distinguished jurist has not been able to reach the summit court of the country. This story needs to be unfolded. I'm sure Justice Sikri would be able to throw some light in regard to what has happened. The Indian Frankfurter, Professor Upendra Bakshi, unmatchable, incomparable in terms of the contribution which has been made by Professor Bakshi to the Indian constitutional jurisprudence and even to legal literature. The story that goes that his name was recommended and yet it never crystallized, one wonders as to what actually happened. Professor Bakshi received an invite from the University of Buffalo, and he had been addressed as Justice Bakshi. When he responded at the seminar at the University of Buffalo, he asked the organizer, the professor, why was he addressed as Justice Bakshi? And he unfolded that Justice P.N. Bhagwati, only a couple of months back, had shared with him that Professor Bakshi would soon be on the bench of the apex court of the country. That never threw as such. Addressed as Brother Bakshi by Justice Chenepa Reddy, Justice D.A. Desai, and that speaks of the fact that with what admiration, with what kind of a respect that Professor Bakshi has been treated all through. It's unfortunate that none of the Indian professor of law or a jurist has been so far able to reach the Supreme Court of India. Same was when I was a young professor of law, we used to hear about P.K. Tripathi, Professor P.K. Tripathi. Even that has not come through as such during all this in this particular background. I have wondered as to what could be the possible reason behind this. The only thing that I could think about, that the theoretical aspect and no practical experience of the laboratory of court rule that a professor of law does not have. And therefore, this particular clause has not been put into actual use so far under the Indian system. You know, this gives a feeling that when the 42nd Amendment was introduced and a similar clause was added in fact by the 42nd Amendment in the year 1976 in regard to the appointment of the judge of the High Court, a distinguished jurist. 2 years later, through 44th Amendment, it stood excluded. If that could have continued and distinguished professors of law could be appointed as judges of the high courts across the country, the kind of practical experience that they would have gained certainly would have further helped in elevating them to the Supreme Court for that matter. Permit me, Justice Sikri, to share my own personal journey briefly in this particular context because it happens to be relevant. I joined the bar in early 1991 after having been at the Punjab University for 21 years. It was early 1992. I was hardly a year or so old at the bar that the then Chief Justice of Punjab and Haryana High Court called me and told me that we are considering you to be designated as the senior advocate. I showed a little surprise on my face. And I was told, be not surprised, the contributions that in the academic domain that you have made needs to be recognized, and therefore, this is what we are seriously considering. I said, not at this particular stage. I had a reason for that. My brother, being a judge of the same court, I told the chief that it would be attributed to you that you have designated him as senior advocate because his brother is a judge of this very court. 10 years later, when I was at the bar, I was designated as senior advocate. Then going to the next step, in early 2013, when I was asked to take over as the director of the National Judicial Academy, my Chief Justice was Justice A.K. Sikri. I went over to him and shared my dilemma. My son told me that these are your harvesting years and you're running away from the profession. Justice Sikri smiled and said, Balram, It's the time when you have to give back to the society. We all make sacrifices, and therefore consider the fact as to why you are being tipped for this particular position. Two things he pointed out. It's a rare blend of academics and the professional skills. And secondly, that throughout you have grown in that environment which is needed for the National Judicial Academy. I was happy to go and take over at the National Judicial Academy. Prior to me, three professors, Professor Madhav Menon, Professor Madan Mohan Gopal, Professor Pillai, had been the directors prior to me. The giants, and they richly deserve to be in that particular field, as such, the distinguished jurists. I had a short stint at the National Judicial Academy. Towards the end of my term, Justice T.S. Thakur was asked to reframe the rules for the appointment of the director of the National Judicial Academy. And in that, the pure academicians stood excluded as such from the domain of being the director of the National Judicial Academy, a former judge of the Supreme Court, a former Chief Justice or a judge of the High Court with a strong academic base and foundation were made eligible to be the directors of the National Judicial Academy. Presently, Justice Raghuram is the director of the National Judicial Academy, a former judge of the Andhra Pradesh High Court. Now, this particular journey that I've shared with you with a particular purpose as such, and that is that if the academics and the practical aspects could be blended together, that to my mind makes the situation far more comfortable in this particular context. I understand, at the Punjab University and also at other law faculties, Justice Sikri was a visiting professor at the Delhi Law Faculty. We also had practicing lawyers as a visiting faculty at the Punjab University. Three former Chief Justices of India were on the faculty of Punjab University. Justice A.S. Anand, Justice M.M. Punchi, Justice J.S. Kher, and numerous judges who had earlier been as visiting faculty of the Punjab University. They got elevated as judges, chief justices of different high courts and high courts. I have shared this journey with a purpose, that the only reason which I could think of as to why so far no distinguished jurist has found a place in the apex court of the country, probably it is felt that they have only the theoretical base. This is a misconception, but yet it needs to be tinkered with some practical exposure. And in that context, if the professors of law could also come into that particular domain, particularly at the Supreme Court of India level, the constitutional jurisprudence requires so much a contribution. Professor Bakshi, if he would have been elevated, or for that matter, H.M. Searway, what an academic mind for that matter. Therefore, this particular exclusion in the year 1978 not to continue to be a distinguished jurist, to be a judge of the High Court, if this provision would have continued, I'm sure the blending of the practical aspect would have been far more. You have taught law, you have become a judge, you have experience of that, and then go to the summit court of the country. That particular journey would have been so good. I would conclude only by saying it's high time that the distinguished professors of law, jurists in the country need to be recognized. And at both levels, this would make the mixing of the entire academic and the procedural aspect or the practical aspect a perfect combination of the two. I look forward to that in future. Thank you so much.
Thank you so much, Professor Gupta. And I do hope everyone can follow your advice and conquer the Everest with the combination of academics and the profession. In fact, you have made my task easier to introduce our chief guest and the main speaker for today's evening's webinar. Ladies and gentlemen, it is Honorable Mr. Justice, Dr. Justice A.K. Sikri. People call him the Professor Judge. It is his effortless flow of words, his charming smile, his pleasant demeanor, and that too in a man who has devoted himself to the pursuit of legal knowledge. Sir, I would like to take the liberty to in fact say that you yourself make for intellectual property. So without further ado, ladies and gentlemen, Honorable Dr. A.K. Sikri.
Thank you, Shruti, for your kind words. My greetings to all the panelists, including Dr. Balram Gupta, Professor Yogendra, and Professor Khagesh Gautam. What should I say? Dr. Professor Lokendra Malik or Advocate Lokendra Malik, who is the spirit and force behind today's event, as he has been in most of such events, and for choosing such an important topic, which I would say has been discussed in academia, but has been totally neglected at the hands of the judiciary. I don't have to say much on the provision in the form of clause 3 of article 124, which was introduced, as Professor Yogesh Pratap has already told you the background in which it was introduced at that time or inserted, which was not there in the beginning, and the debates which were held or conducted in the Constituent Assembly. He gave a glimpse of that. Fact remains that from 1950, from inception, from day one, when the Constitution was promulgated, this provision is there of a distinguished jurist. Fact also remains when we talk of jurists, and as the Constituent Assembly debates would demonstrate, that by giving the expression jurist, the constitution makers had teachers in mind, legal academia in mind. That is why the example of Felix Frankfurter was given. And so, because who was himself a law professor and became judge of the Supreme Court, and justification was given by saying that, look, when there can be a professor who can be, if he becomes judge, who can contribute immensely to the growth of constitutional law, which is unprecedented. Even those who have come from bar and became from the advocates category and became judges, were elevated as judges. He has surpassed all those contributions of all those persons also. So therefore, we need to have somebody distinguished jurist. And interestingly, there was some discussion in the Constituent Assembly even on the word distinguished, whether distinguished should be there or eminent should be there. But ultimately, the word distinguished was chosen. It's an interesting uh, debate on that also. But then, what I'm trying to say is that the professor to become judge was in the at the back of the mind of the constitution makers when this provision was introduced. Of course, I may say at the same time, when the word jurist is there, it doesn't necessarily mean that it would be confined only to the academia. It may include from other fields also. I mean, even a lawyers who are jurists. So it can come. And interestingly, there have been two examples. Although the two judges who have been elevated up to now, they otherwise don't fit in the criteria formulated in Article 124 otherwise, and therefore it is said that they were brought in this category of jurist, and that can be the only explanation, although it is not on papers. But the fact remains that from academia nobody has been appointed so far. Now, very interesting aspect, and I'll, because Professor Lokendra Malik also said in his initial remarks that I should be giving some practical, or rather, what was happening or what had happened up to now. So I should share whatever my knowledge is, and which I acquired earlier or after I became judge of the Supreme Court or after I entered the collegium. I'll like to share that. No problem. Make this discussion more lively as well. Of course, in addition to what others have also shared about, and particularly the example of Professor Tripathi and Professor Bakshi, which have been given. Now, let us start with, I want to start a little differently with the role of a professor, a law professor versus a judge. So instead of here becoming law professor as judge, first I am saying let us have this scenario of professor versus judge as to what are their roles in their respective fields. We know, insofar as judges are concerned, and it's not only a matter of common knowledge, I can say from my experience also, and particularly in Indian context, and the judges of high courts or the judges of Supreme Court, they are very much overburdened with their work. The work is immense. Everybody knows the kind of arrears, backlog, etc., and how many cases we are supposed to decide. In this whole process and in this background, when there's a pressure of time, insofar as judges are concerned, and when they write their opinions, obviously they are not in a position to, and they are not able to do that kind of in-depth study into a particular um, issue which has come up before them. And let us to be in order to bring home the point, I'm now discussing only constitutional issues and digressing from other kinds of issues, although it may apply there as well, and or other issues of moments, maybe in other laws as well, but particularly constitutional issues. And let me tell you from my experience as a judge of the Supreme Court, which I remained in 6 years, and I was part of so many constitution benches where we delivered the judgment, where such important issues came. And in last few years, if not necessarily before me, but in many other benches also, the kinds of issues which have been coming up, they require an in-depth study about those issues. Of course, I can say so that as judges, we were given much assistance by lawyers, because when these are the issues of moments and such important constitutional issues, we have a, I can say with pride that we have a very rich bar in the Supreme Court, where some of the lawyers are outstanding lawyers. They are comparable to any lawyers in the world. And therefore, they are able to render that kind of assistance, which is highly qualitative. And they do a lot of research for us. But that is one material given to us. Other is, as of today, that yes, we have the assistance of our law clerks also, which may do research for us. But apart from that, what I'm trying to say is that there's not much time, and therefore under pressure and for lack of sometimes specialization also in a particular problem, the judges in India are all journalists and not specialists. They have to decide these cases. What is the role of professors? On the other hand, professors, after all, they are teaching in the law schools, and since we are talking of law professors, but apart from that teaching to students in the law school, they undertake the work of research as well, for which they have time in abundance. So one of the important role, apart from role in the law schools, which the teachers are able to play, law professors are able to discharge, is that they come out with their writings, their essays, and in addition to that, when the judgments are pronounced, critique of those judgments as well, which are given from time to time. And I want to say here, and that is my hypothesis on which I will develop, that why law professors need to be judges as well, and why not Article 3, this Clause 3 of Article 124 be implemented in that sense. That what is the, contribution of academic scholarship insofar as judgments of the courts are concerned, and how it has impacted the growth of law, even when the law professors have not been judges, but by their contribution, by their writings. I will first go anecdotal, and 3 or 4 examples I will give. And these are those persons, most of them, not maybe all, who have been, as we have discussed also, who have been, at one point or the other were considered or even recommended for judgeship. You know, the relationship between, if I say, causal relationship or otherwise relationship between fundamental rights and the directive principles of state policy. It had been the view initially of the Supreme Court that whereas fundamental rights are justiciable, directive principles are not justiciable. I remember Professor Tripathi writing way back in 60s an outstanding article that directive principles should not be given a lesser importance than fundamental rights. Both should stand on same footing. When we talk of, because we are not now discussing elaborately on that, because our theme and our focus is on the appointment of law professors and not on these subjects, but only as an example of growth insofar as law is concerned. So he criticized the Supreme Court in its initial judgment which were given by saying that, look, the directive principles should be given same importance, which was realized by judges during the course of time and in late 70s and 80s. And it resulted in a new jurisprudence which was developed by the Supreme Court. Was this, that although directive principles remain unjusticiable, but many of the directive principles, their facets are taken up in interpreting Article 19 and 21 and Article 14, etc. And therefore, they have become like right to life. when we say right to life with dignity, and this right to life with dignity, when we create right to food, right for employment, and all other things which find part in part 4, that is the fundamental duties. But this was initially what was said by Professor Tripathi in 60s, was accepted in late 70s or early 80s by the Supreme Court. I give you another example, and that was this, which many people may not be even knowing. Because of certain discussions, etc., I came to know about it. That Professor Tripathi had written an article and he had discussed this matter also. When we talk of constitutional amendments, now the question is, or we talk of judicial review. Now, a law which is passed by the legislature, an act is passed, and its validity, constitutional validity is challenged. In judicial exercise of power of judicial review, the Supreme Court goes into the question whether it is constitutionally valid or not. That's the test. That is, whether first is ultra vires, whether the legislature, that's the parliament or the state legislature, had the power to make that law in the light of Article 246 and 7th schedule. And second is that it does not offend or infringe any of the provisions of the Constitution, including fundamental rights. Now, what happens when the Constitution itself is amended and the amendment comes for challenge? We have the cases where constitutional amendments have been challenged. Now, can then be said a constitutional amendment is wrong because it is violative of any other provision of the Constitution? If that be so, then Article 368 would not give, then there cannot be any power to amend the Constitution. So therefore, this gave rise to, which was accepted in Keshwananda Bharati, that normally not, but then there should be some features of the Constitution which are amendable. And therefore, those amendments should not be allowed. And Keshwananda Bharati accepted the doctrine of this basic feature of the Constitution, which was there. And many people don't know that these two were the, in a way, are the the contributions of Professor Tripathi. And take the example of, now I say about equality under Article 14. Now, equality and initially what was laid down by the Supreme Court was that equality can't be in absolute terms, which may be correct, and therefore reasonable classification. That is only equality among equals. But then Professor MP Singh at that time criticized and and he talked of affirmative action. He said that in this, insofar as when it comes to affirmative action, that positive discrimination and in particularly in respect of reservations, etc., then one has to keep in mind a different set of principles. And to cut it short, again, I'm not going into this, which ultimately gave rise to Mandal Commission, which was accepted by the Supreme Court in that Indra Sani case, which is a law. And but still, even till date, Supreme Court is struggling with insofar as matters of reservations are concerned. If you go into the jurisprudence which is developed by Professor MP Singh on this equality, I think that may give, of course, it was accepted to some extent, as I've said, but then it can bring the chapter to a close, and the court may find a lasting solution on it. Professor Bakshi, his not only contribution when the PIL had just started, saying how PIL should be considered, how this jurisdiction should be considered. He himself filed the cases and argued in the Supreme Court himself in the 78, 79, 80s, etc. I still remember I was a young lawyer at that time. He was my teacher as well, and would find him in the corridors of the Supreme Court arguing such matters. and coming out with the, apart from many other writings, for the jurisprudence which is created and which is called demosprudence. It is what the Supreme Court has been doing. And as rightly pointed out by the earlier speakers also, that he was called, I mean, other judges of that time used to call him as brother. And in private, many discussions which would take place, they would then incorporate in their judgments, jurisprudentially, the acumen of Professor Bakshi. So these are some of the examples which I would say are there, on the basis of which you can see, I give only one last example, and thereafter I'll come to this Article 21, that nobody shall be deprived of his except by process of law. The question fell for consideration in the very first year. What is the meaning of, whether it includes due process or it is only simply a process? Because of the expression in America, where the due process is there, which the Supreme Court has accepted. We know this journey from Khadak Singh up to Menka Gandhi. And let me tell you, this is, I'm saying from my, again, experience. I was in the court when this case was being argued against, again, a new judge. And one article by a professor was cited by a professor in Delhi University, I'm not naming, he's not there now, was cited, who had discussed about due process. A very young professor at that time in Delhi, and which, in my presence, I still remember the judges at benches said that this is really a theory propounded by this professor in this article, which is worthy of acceptance, and that resulted in that judgment. So therefore, what I'm trying to say is, from all this, that the contribution of professors, of law professors, in the development of law in India, constitutional development, has been tremendous, even when they have not been able to come on the bench. How their thinking have impacted. What the Supreme Court jurisprudence would have been there, or constitutional jurisprudence would have been there, had there been these persons who would have adorned the benches and given more meaningful contribution day in and day out while sitting as the judges. That is what I wanted to say from all this discussion. You are right. As we said, first let me tell you about Professor Tripathi. As I know personally, first time his name was sent, recommended. You know, at that time, the then law minister, he writes, he says he is an outstanding, distinguished law professor, but what he writes, and therefore he should be appointed as the judge of the High Court. It was a very decent way of denying him the judgeship of the Supreme Court, that he should be appointed as judge, whereas the recommendation was for appointment as judge of the Supreme Court. Second time, name again went. At that time, Justice Pathak was the Chief Justice. And Justice Pathak himself said to somebody, and I've heard it from horse's mouth, later, much later, he told somebody that, look, I wanted to appoint him. Today I regret that when I discussed this with my colleagues, some of my colleagues objected to it. And I regret that I did not have courage, because at that time there was no system. So Chief Justice was Chief Justice, he was not bound by what other judges say. So he just took their words and therefore did not take this bold step, only for fear of backlash from his colleagues, since they had their reservations. But he said that I committed this mistake. He, in a private to somebody, he said, and I know for certainty that he had said so. As far as Professor Bakshi is concerned, as you have rightly said, but I also do not know at what level and where it was taught. But what I'm trying to say is that there has been some kind of indifference as far as sitting judges in the Supreme Court are concerned. And I don't know, I should not say other strong words, but yes, that's why I've used the word indifference. And that for some reason they think that maybe, one of the reasons which is said and which is discussed also is that, look, they are not trained like lawyers. Because you need the practical aspects and practical sides of a lawyering who has practiced for so many years in order to give good judgments, because that aspect, that kind of diligence and that kind of expertise is required. That kind of skill which you acquire while practicing as a, in the court for few years is required, which they do not have. But then my answer to that is very simple. I give twofold answers. Number one is that since this provision is there, I'm first talking about the Supreme Court. Since this provision is there, and Supreme Court, as there's another debate which always goes on, that Supreme Court has become a court of appeal only, and it takes up all kinds of matter as appeal. Why it should not be treated as a constitutional court? It is primarily and basically a constitutional court. Number one. Number two, as we know, and all of you, since are the professors and students of law, etc., that there are, which I said also, so many types of important constitutional cases come up. Even today, so many matters are still pending before the Supreme Court, which are a constitutional bench matter of 5 judge, 7 judge, 9 judge, 11 judge bench matters are still pending. 1 or 2 I still remember. Now, why not appoint from academia a judge in the Supreme Court who should sit in constitution bench? Then this problem, so-called problem, is automatically taken care of. Number one. Number two, as Professor Balram Gupta rightly said, after some years on the bench, a good, because we are talking of distinguished jurist, a person who is distinguished jurist will be able to pick up the nuances of legal profession also in no time. Some he would be having or she would be having, others she would be able to pick up. So therefore, after a couple of years or 3 years or 4 years, they can do other work also. But even if not, why not utilize their expertise and put them in constitutional benches, which should be there always, doing one or the other constitutional bench, and their contribution may be immense. So therefore, I feel that this is a provision which has remained unutilized, which should be utilized. I would say at the end, yes, I had been a part of collegium. To that extent, I should bear the burden of blame. Since during my period also I couldn't do. But I can only say one thing, and not more than that, that once I tried to approach this subject with other colleagues, and as I said, the reaction was such that I knew that for time being nothing is going to happen and I would be a lone voice. Coming to only one last thing I would say is that this is again what I'm saying is said. And I know another person, even Professor Madhva Menon name was also, was in circulation at one point of time, and it was discussed that he should be appointed. So what is discussed is that, look, today we don't have persons like Professor Tripathi, like Professor Bakshi, like Professor Madhva Menon, like Professor MP Singh, etc. But my answer is simple to them. You cannot, first of all, they became stalwarts after so many years in teaching. We may have, and you cannot think that no, there are no persons, other persons. What we have to see, that they don't become the benchmark. That just any person to be qualified as a judge from academia should be of a caliber of Professor Bakshi. That can't be. Benchmark is laid down in the constitution, which is a distinguished jurist. So if a person is found to be a distinguished jurist, person should be appointed. And so therefore, what I feel at the end, that this is one unutilized provision, and maybe had NJAC not gone, and uh, uh, when the NJAC has been declared unconstitutional, but in that selection committee where the persons from outside, including jurists, etc., were there, they might have recommended. But let us see, and I only hope that uh, some good sense prevails in the collegium, and this provision is fructified, and we see at least the beginning of that. Thank you.
Thank you so much, Justice Sikri. Indeed, you have discussed at length something that we have all wanted to voice, but it's out for the public to now dwell over and probably relish it at a later stage when the collegium does take the bull by the horns and does something about it. Professor Gautam wants to make a short comment, so I would request Mr. Malhotra to unmute him.
Dr. Bedi, thank you, and Justice Sikri, thank you for those most interesting and very insightful remarks. I wanted to make a brief comment about Justice Sikri's comment on the distinguishment, or the distinction rather, between theory and practice. This is a common argument that has been made in quite a few other jurisdictions, that a law professor might not be the best suited to be appointed to a court because of their lack of practical experience. I most respectfully and with greatest humility, I submit to you that the distinction between theory and practice is an artificial distinction that, if you examine carefully, can't be maintained. Now, of course, I could be incorrect, and as the youngest member of this panel, I already add a caveat that my logic might be found to be flawed by people who have more learning than me in this. But here is my argument in brief. You see, there is a very famous distinction, or rather a discussion in legal theory about the use of rules and standards. Sometimes you have bright line rules, for example, standard deduction in the Income Tax Act. That's a rule, it's not subject to interpretation. 1 lakh rupees is 1 lakh rupees. On the other hand, you have certain areas where there are standards where the legislation is enacted, and the details of how to work that is actually left to the courts. Now, whenever a standard is to be used, the judge or whomever the judicial decision maker is, they have to exercise judicial discretion. And Justice Sikri, of all people, knows best of all the people in attendance today that there is no way to objectively lay down the criteria as to how judicial discretion is to be exercised. Ultimately, and in the final analysis, judicial discretion remains subjective, but we trust the judges because as a result of their long years and practice at the bar and the wisdom that comes from it, they will be in a better position to exercise that discretion. Now, the law can only state that discretion is to be exercised, but it can never completely and accurately describe what discretion is. Any distinction between the phenomenon that is described as theory and practice is ultimately, in my opinion, ascribable to this inability of the law. And it's not the inability of law, it's a human inability. Now, therefore, I believe distinction between theory and practice can exist to the extent it's a subjective distinction, and exists only in the mind of the people who identify as theorists or practitioners. In truth, the distinction cannot exist. So therefore, I think we should withdraw this objection that judges, law professors don't have practical experience. What is the meaning of the phrase practical experience? Ultimately, it has no inherent meaning. It has whatever meaning we want to give it. But in the process of maintaining this false distinction, we have continued to disenfranchise a community that has continuously contributed and for no good reason has been left out from doing national service.
Right. Thank you.
Let me only 1 minute I'll take.
Sure,
First of all, actually, Professor Gautam, you have misunderstood me. I said this is the feeling. I didn't say that it is correct. But let me tell you from my experience. it is that. And Dr. Balram Gupta sitting here is the best person to say that, because he has been a teacher first, and then he has seen the practical side also. He had been an advocate, practicing advocate. Let me be very frank and blunt in telling you, there are hundreds of circumstances and hundreds of cases which come up where practical experience do matter. This is my first. But having said so, in this aspect, what I say, when you reach that may be at the level of deciding the case at district court level or high court level, that to high court original side, etc. But that may not apply. Now I'm saying something in your favor again. May not apply when it comes to Supreme Court, because Supreme Court here we are only deciding the questions of law, and that too also important question of law. And when these questions of law only are to be applied, answered, and law is to be applied, and particularly in constitutional context, this distinction becomes irrelevant. So that should be the approach in answering what you are saying. Not if you stick to the point that no, there is no distinction, nobody is going to accept that. But yes, this distinction becomes blurred or stands abolished when it comes to the role of a judge in the Supreme Court. That is the point. There you score.
Can I take a minute? Just a minute.
He has to be unmuted.
See, the point that I wish to make, the practical exposure makes all the difference as such. You know why I'm saying this? Because there are certain things which a professor of law would have never an exposure to them. And therefore, as Justice Sikri has pointed out, that there is a distinction. You can't say that there is no distinction at all. But in certain domains, like the constitutional domain, what can be done as such, the professor can make contribution. But otherwise, you know, even in the judicial academies, professors of law who had never an exposure of a day in the courts as a lawyer or as a judge are not now to be considered as the best persons to head the judicial academies. Judicial education has come to be senior judges come and share their experiences with the younger judges. And therefore, the practical aspect is also equally to be considered in this particular context. This blending is most important. Thank you so much.
Thank you, Professor Gupta. Indeed, it has been an extremely interesting debate and discussion. And I agree with the panelists that it's high time, and in fact, it's a great deal of satisfaction to see that such subjects are indeed being discussed and debated for bringing this up. Thank you all very much for being a part of this evening. And I, for one, have thoroughly enjoyed myself. My sincerest gratitude to honorable thoughts on a subject which is close to the heart of all academicians, although, as he rightly points out, that it's not only the law professor who deserves the category of a distinguished jurist, but we can include and widen it so much more. Thank you. Thank you, Professor Balram Gupta, for sharing your experience, which lays the groundwork for such a step being taken forward. Professor Yogesh Singh has discussed the comparative aspects, has given examples of other countries, particularly from America, Justice Frankfurter, Justice Anton Scalia, from the recent years, where again we can look to them and imbibe something that will benefit us greatly. Thank you, Professor Gautam, for sharing your insights on this topic. Dr. Lokender Malik, it would not have been possible without you. and our sincerest gratitude to you again for thinking of something like this and for making it happen. I thank the audience who has been patient and actually deserves a good mention because they are the ones to whom we speak to. So thank you for being there. And in the end, I would also like to thank our student here, Arpit Malhotra, for offering the technical support during this Zoom
Professor
webinar.
Bedi,
Thank you, everyone. Stay safe and take care.
Thank you.
Yes, sir. Dr. Malik, would you like to say something? Otherwise, we are done.
Professor Bedi, special thanks to you for being the moderator of this great
Excellent
event.
moderator. Yes, yes. Thank you. Thank you.
Without your support, this would never have been possible. So I'm deeply grateful to you for your kind support, cooperation, and encouragement. Thank you so much.
Thank you, sir. It's an honor for me. Thank you.
Thank you.